再稍微講咯，我準備拉嘅，點會嚟拉嘅？唔好意思啊，
Ladies and gentlemen, the afternoon event will soon commence. Please be seated and mute your phone to silent mode. Thank you. Welcome back to the afternoon session of Day 3's Hong Kong Legal Week 2023. There will be two-part sessions on arbitration conducted in English this afternoon. The first session will be the fireside chat on the future of arbitration issues around the globe. And the second session will be a panel discussion on experience sharing of the practice of arbitration funding in major arbitral jurisdictions. Please note that simultaneous interpretation services will be provided in Cantonese and Mandarin. You may choose the preferred language as shown on the screen by clicking on the channel directly. If you need a headset, please raise your hand and our staff will provide you one. 我们提供即时传译的服务，并设有粤语及普通话的频道。在场人士可以用会场的入口处领取耳机。如果您现在需要耳机的话，请举手，我们的工作人员会向你提供。线上同步参加的人士 你可以透过直接点击屏幕上显示的频道，选择相关的语言。谢谢。 Welcome back, ladies and gentlemen. Without further ado, let's proceed with the first session, Fireside Chat on the future of arbitration issues around the globe. We have our moderator, Dr. Mario Dempsey, Secretary General of the Hong Kong International Arbitration Center, and our guest speaker, Mr. Matthew Townsend, partner of Reed Smith Richards Butler LLP. Dr. Dempsey, the floor is yours, please.
Thank you very much. Good afternoon, everyone. I realise we have the unenviable position of the graveyard shift after lunch today, but I can think of no better way than to wake you up from your post-lunch slumber. So without further ado, I will introduce my fireside chattee today, Mr. Matthew Townsend. As mentioned, he's a partner at Reed Smith here in Hong Kong. He is a Chinese speaker, far better than I am. We could have done this in Mandarin, but for my language capabilities, so you will have to deal with us in English. He worked in the PRC for 4 years before moving to Hong Kong in 2014, and he's been here ever since. He's a qualified lawyer in England and Wales and Hong Kong, and he'll correct me if that's incorrect.
Unfortunately, it's just in England and
Just
Wales.
in England and
I'm very
Wales.
sorry to everybody here.
Sorry, we're off to a good start. In any case, today we'll discuss a number of topics. One of the areas that Matthew is a market leader in is the area of tech, including AI, which I'm sure most of you in the room will appreciate is the topic, or are the topics on everyone's lips in Hong Kong. We'll also talk about his unique experience in practicing both in mainland China and in Hong Kong, and also in other jurisdictions before that. And we'll talk a little bit about advocacy, legal tech, arbitral procedures, and all of that in the next half an hour. So without further ado, I will get started. Matthew, welcome, and thank you for joining us today.
Thank you very much, Mario.
Let's get straight into it. How did you get into arbitration in the first place?
Okay, well, very quickly, I come from a very rural part of southwest England. And actually, to give you an idea of just how non-international my background is growing up, a neighbor once came to me and confided in me that he was taking his first ever trip abroad. And in order to do so, he would have to go to London to get a new passport, or to get his first ever passport. And he then confided in me that this was his first ever trip to London. So that's my kind of the environment in which I was raised. It was a very rural environment, and as such, when I went to university, I had a passion for trying to see a bit of a world, to get out of England and ideally Europe, and that led me to studying as international relations at university, and then ultimately to taking a job in mainland China in 2010, when that was still a fairly unusual thing to do, and I was lucky enough to get a role at an international law firm in China, mainland China, working for a number of SOEs on a raft of arbitrations. So I've been very lucky, and I've started from, I would never have imagined that I'd be sitting in Hong Kong talking about arbitration all those years ago.
Thanks very much. As someone who did a similar thing in Brisbane, Australia, I can totally appreciate the desire to use arbitration as a way to get out and see the wider world. Turning right now to where you just left off with your experience, or your very unique experience in mainland China. What was it like working as an English arbitration lawyer there?
Yeah, thank you very much. I mean, I think I have got quite unique experience for an English arbitration lawyer, but of course there are a number of mainland Chinese and Hong Kong colleagues who are extremely experienced in this space. Now, I spent, as I said, 4 years at the Beijing office of Fulbright and Jaworski, subsequently Mortimer as Fulbright, and was just fortunate because I was the only individual who did arbitration work in that office. And in Beijing, as you know, it's FaceTime goes a long way. So it was very important that we jet around in taxis, seeing clients and making ourselves physically available. And that led to a number of opportunities that, as a fairly junior arbitration lawyer at the time, I was very lucky to experience. So, for instance, I was representing a state-owned enterprise in an arbitration against a European state. They had the entire negotiation in mainland China in Beijing. I got to be the only English speaker on the SOE client side. We concluded an agreement, and we would have got it executed in time, but unfortunately it was a Friday, and I could find no individuals capable of executing the document because they were all at the cinema watching Transformers: Revenge of the Fallen. So that unfortunately ended up being executed on the Monday instead of the preceding Friday. But I mean, that kind of experience was far above my pay grade as an English lawyer, and had I been in the UK, it would have been I guess my supervisor's job.
Thank you. I think you're dating yourself with that reference to the movies, Matthew. I think nowadays they'd be downloading it or watching it on Netflix, but leave that to one side for the time being. Since you have been in Hong Kong now for a decade, how have you seen the arbitration market in Hong Kong change in the time that you've been here?
Yeah, absolutely. I mean, I see some very experienced practitioners and in the audience, and I'd be kind of interested in their views, but certainly from my perspective, 10 years ago, when I was a fairly green arbitration lawyer in Hong Kong, where there were larger quantum arbitrations, I would tend to see the adverse party represented by one of the international law firms, and it was rare that we would come up against kind of Chinese law firms or perhaps smaller law firms from elsewhere. Now, anecdotally, and it may just, in fact, it may be, Mario may be in a better position than I to make a better assessment, but anecdotally, I'm finding many more Chinese law firms on the other side. I'm finding many more smaller law firms instructing barristers, counsel, whether from Hong Kong, the UK, Australia, or elsewhere. And as such, I'm getting a greater diversity of counsel representative.
I think I can confirm that. I mean, we are seeing an increased diversity in the law firms that represent parties at the centre in any case. So focusing from the macro, I guess, down to more specifically yourself, how has your practice developed in the time that you've been here? I know that you've worked on a couple of industry first matters, and perhaps you could tell us a little bit about those.
Yeah, absolutely. So as I said, I've been very lucky to have spent quite a long time in this market, and this market is constantly evolving. I mean, we've got Catherine Sanger here, and you know, ORFS is an area that you're going to be learning more about today. There's been a number of advancements in the arbitration rules, in the soft law and the hard law relating to Hong Kong. So I've been lucky to be kind of captured by some of these developments. The first of which was the first HKIC administered arbitration, for which there was an emergency arbitration which went to a full hearing. I believe there's now been over 30 of those matters, but we were the second respondent, I believe, in the first one to come to the HKIC. And so, of course, we had Mario's predecessor kind of sitting in and observing. And unfortunately, well, having gone through the entire emergency arbitration process leading to the hearing, we had a consistent complaint in our pleadings that the relief requested was not properly phrased or not properly specified. And when in the first hour of the hearing, the arbitrator asked the claimant to restate their relief and write it down and come back. And unfortunately, the relief that was drafted made no mention of my clients. So the arbitration hearing for us was very short. We left shortly afterwards and started drafting our cost submissions. But nonetheless, it was it was an extremely interesting experience. And there's been a few other matters where, as I say, you know, just being in Hong Kong, where the arbitral landscape is changing so quickly, I've been able to be involved in certain cases. For instance, some of the first cases involving the interim relief arrangement between mainland China and Hong Kong SAR. with a previous law firm. And I found that to be an extraordinarily robust tool and a very useful one in bringing parties to the negotiating table.
Yeah, I think that's a common sentiment here in Hong Kong. The market's so dynamic and everything's changing and quite quickly. And also, to go back to one of your earlier points, you will get exposure here due to a leaner team generally to more significant work at an earlier stage in your career than perhaps elsewhere. Now, on point with the Hong Kong market, I'd be interested in hearing your views on whether there's a difference between local and international arbitration, and if so, what it is or what they are.
Yeah, I mean, that's a very interesting question, and one I hadn't really given much thought to prior to today. Of course, as an international arbitration practitioner, like many people in this room, I have a bias. Certainly when it comes to some of the, what I would call the killer apps of arbitration, the ability to appoint a neutral tribunal of an independent nationality, the ability to choose a seat where the supervising courts are from a jurisdiction which is different from the parties' jurisdictions, and so forth. And of course, the cross-border enforcement mechanism contained in the New York Convention. Those are not necessarily some of the advantages of domestic arbitration, but certainly what I think is the most underutilized killer app, if you like, of arbitration being its flexibility and the confidentiality of arbitration are certainly aspects that you can utilize in domestic arbitration. But for me, I guess as a kind of personal question, for me, it's really the international, and going back to a point I made very early, for me it's the ability to interface with different cultures, different legal cultures, jurisdictions, nationalities, languages that I find so fascinating, and it can lead to pitfalls. So for instance, one of my first arbitrations in Hong Kong, and I'm not sure if the arbitrator is here, but we were representing the claimant. The respondent was on the eve of cross-examining our leading or our primary fact witness. The other side kindly sent a 4-page PDF containing all of their cross-examination questions that they intended to ask, which was, you know, probably the first and the last time that I've seen that happen. So, you know, it's these things that kind of really bring you to realize how different the legal traditions are with all the parties coming into this melting pot of arbitration.
So if that's your sort of take on your current experience, let's just take a quick look into the future. What do you think are some of the key issues that will affect international arbitration in the years to come?
Well, I mean, again, there's lots of senior practitioners here who have their own views. For me, there are a number of issues, but I am particularly cognizant of the waste and inefficiency that can arise in some arbitration procedures. And it's very easy, of course, to assume as a default that an arbitration procedure should involve certain steps. But I think it's incumbent on us as counsel and arbitrators also to decide whether, for instance, multiple rounds of witness evidence is necessary, whether meetings of experts is necessary, whether some of these stages of the arbitration procedure, which have become very much the default, are actually required. And of course, that's my primary kind of personal bugbear, but there are very important issues surrounding the credibility of arbitration. I know that there was an UNCITRAL report released in the last, I think, 48 hours, talking about the credibility of investor-state dispute settlement, and it's incumbent on us all to ensure that there is a robust, fair, and transparent process.
Couldn't agree more. Just circling back to one point you made about efficiency or inefficiency. Are solutions to the efficiency problem to be found in procedural mechanisms, or what would your take on that be?
Yeah, so there's been quite a bit of discussion in my firm personally around summary disposal of arbitration. I know that this is a tool which is, I guess, fairly underutilized, and for understandable reasons. If you're an arbitrator, there is a concern that in using any tool which may be perceived as limiting the ability of the parties to have a reasonable opportunity to present their case. But I am interested in summary disposal, and where an issue is determined early on in the proceedings, or with without a large amount of submissions going towards it. And I think whether the extent to which these kind of procedures are used will depend on culture. And certainly in the courts, there is a culture of using these kind of procedures fairly routinely. And it's interesting to see, for instance, the amendments to the English arbitration law, where the power to summarily dispose of issues, which has been an implied power, is now being written expressly into law, or is proposed to be written expressly into law. It seems to me as an effort to change the culture, to reinforce that this is something that can be used. So I think watch this space. I haven't made up my mind whether it will be used a lot or not.
Yep. Certainly the effect of having things that are probably already allowed being written in a claritory or a clarifying way into law will probably, move the dial in the right direction. Switching tack right now to AI and that kind of technology area. Generative AI, do you use it?
Generative AI I do use, and I use it every day, but I only use it while using bespoke and secure tools, which are custom made for my law firm, as I believe representatives from other law firms will have in common with me. And only as the initial step of producing a work product. Certainly, I'm not in the habit of entering, do some legal research on X into a chatbot.
You might have just preempted my next question.
Yeah.
What do you perceive to be the opportunities for international arbitration specialists when it comes to AI? And I guess I'll add to that question, what do you see the risks there as well?
So I actually think that there's an emerging consensus, or an emerged consensus among arbitration lawyers that AI is a very useful tool. It will not make lawyers redundant, but the lawyers who use AI as a tool will be more efficient, will have the ability to be more responsive to clients' needs. And I agree with that perceived consensus. I mean, I think we've moved within a few months from the cases where arbitrators or judges are simply, or counsel are simply asking a chatbot to do some research or produce a pleading or something like that, because obviously there are issues there with confidentiality, with a lack of complete data, and the concomitant risks of hallucinations, as well as the fact that AI is really, large language models are really a black box, and unless you have a software which is capable of reading that software, it's very difficult to tell where the result, where the answer to your question has come from. So I say, I mean, it's an extraordinarily powerful tool, a very accessible tool, and I certainly use it, for instance, in arbitration pleadings, preparing chronologies, first cuts of chronologies, preparing, some example cross-examination questions for an expert report, comparing expert reports, etc. But I would very much emphasize that this is only where you have a kind of a secure third-party produced product where you have NDAs in place. And in fact, I would even be cautious using my tools of using client confidential information, even where there is an NDA in place. So I think it's incredibly powerful, very useful. And I guess another thing I'd say is that this isn't, of course, the first time we've talked about AI. It's a recursive technology. Every time that you have a new innovation, a new development, building on a new development, then it comes into the kind of zeitgeist, and lawyers start scratching their heads. Now, the last time this happened was, I believe, 6 years ago, when deep learning technology became I guess, to kind of enter the zeitgeist. And at that time, there were discussions about, robo-lawyers and will we be replaced, etc. I'm quite interested by the fact that this time it's come around, we're talking much less about whether we will be replaced and much more about the kind of the tools that we can use and the, it's become a much more practical discussion, I think, which reflects that we're becoming a lot more comfortable with the technology.
I have flashbacks to when Google Translate first came out, and in working in an international law firm where multiple languages were always in the documents we were using, just putting everything in there until we got a sternly worded email from the managing partner informing us that we didn't know where our data was going. So this is going, of course, one step further than that altogether.
Absolutely.
Turning to your experience with the Chinese courts, as I'm told, AI is already being used as a decider of disputes in some Chinese courts. Could you tell us a little bit more about that?
Yeah, absolutely. I have no experience of resolving disputes in the Chinese courts involving AI, but it is happening. I'm reliably informed. And this, I think, goes back to the question of, okay, so we as counsel, predominantly counsel, perhaps as arbitrators, are using AI to assist in putting together the initial building blocks for our submissions, our awards, our analysis. But what about you could call it the more remote idea of AI being used to determine disputes? And I say it's remote, but it is, as you say, being used, as I believe in the Chinese courts, is being, I think that some online platforms have AI dispute resolution mechanisms. I'm afraid to say I haven't used them. But the question is, first of all, is this method of determining disputes useful? And I guess, second of all, a slightly more philosophical question, which is it a true determination of a dispute in the way in which we are accustomed to seeing these determinations take place? And actually, I'm reminded of a discussion which we might have been having a year or two ago about on-chain dispute resolution of the type of, for instance, Kleros or Aragon. And the on-chain dispute resolution mechanisms were a mechanism where a dispute is referred to a jury, loosely phrased a jury of anonymous token holders who pledge their tokens, wagering in effect on the outcome of a dispute. And the idea being that game theory would mean that if you allowed the individuals who wagered on the dispute to recover a return on their tokens in the event that they sided with the majority, and you provided that the token holders who bet wrongly would lose their tokens, well, then you get a sort of de facto kind of dispute resolution mechanism. And that, I think we can probably all agree, is not really arbitration as we understand it, betting on the outcome. Well, I think with large language models, those who understand it better than me could probably explain this a little bit better. But where you are looking at a probabilistic prompt analysis in order to ascertain what the outcome of a dispute is, well, is that really determination in the way that we are accustomed to? No, it isn't. Does it have a place in resolving, for instance, smaller disputes or disputes where the parties are or entering into the adjudication mechanism of open eyes, well, perhaps. So it's a long way of saying that what I love about this kind of technology is it really makes you think about what a true determination of a dispute is or what it should involve.
Since we're already well into the topic, what other ways do you think technology is changing the arbitration process?
Yeah, sure. Well, personally, I think that in Hong Kong, during the period of COVID, virtual hearings, hybrid hearings, in one way, perhaps there was a silver lining to this process, in the sense that, for me at least, it really highlighted the importance of EPE, electronic presentation of evidence. And I know that this is something which is being used a lot in terms of demonstratives, and also just in terms of bringing up documents in an arbitration hearing. But I think that this is an area which is extraordinarily powerful, and when it comes to electronic presentation of evidence, I think there's a lot of scope for advocates to use electronic presentation of evidence to put their case. And I think that when properly used, I think it can represent a shift in the balance of power from for instance, the expert or the witness being cross-examined to the cross-examiner, who can control not only the questions, the pace of the questioning, the scope of the questions, but can also control and influence the presentation of that evidence to that witness and to the tribunal as well. If you add to that the ability to prepare demonstratives, perhaps in high-value cases, even immersive demonstratives, to put your case, I think that this can add an entire new dimension to advocacy. And I certainly haven't I'm certainly a little bit halfway through my kind of journey in this regard, but I think there's tremendous potential there, as I say, in shifting the power to the advocate and adding a new dimension to advocacy.
Thanks for that. Now we have 1 minute and 48 seconds to go, but since this is Hong Kong Legal Week, I couldn't end this interview without asking you about your views on Hong Kong's role in the regional development of arbitration. Are we fit for the future?
Are we fit for the future? Well, it will be no surprise that my view is absolutely yes. I hope, certainly among my colleagues in different jurisdictions, I hope that there is an understanding that Hong Kong is a place that's fit for purpose for the resolution of commercial disputes. I know that you only need to look at the decisions of the Hong Kong courts in the last 2 or 3 years to see that Hong Kong courts are extremely voraciously pro-arbitration. There is there's an extraordinary effort to make independent and impartial decisions. And of course, Hong Kong's had a raft of amendments and improvements to their arbitration infrastructure. And as I'm told that we have 1 minute, I believe one of these will be discussed at great length in the next session. So my focus is to, having gone through this very hard period for everybody, the COVID period, to make sure that people come to Hong Kong. I know we have some international visitors today, and I'm aware that ICA will be an extraordinary opportunity to bring people back to Hong Kong and to fall in love once again, with a place that they once had a tremendous affection for. And I'm very much looking forward to working with everybody to sell Hong Kong to the world again.
Thank you very much, Matthew. And also for mentioning ICA, which of course I'm sure most people in the room are very aware, is one of the largest, well, the largest regular arbitration conference in the world. It's taking place in Hong Kong next May, and we're expecting about 1,000 visitors from all over the world. So in the spirit of your last sentiment about bringing people back to Hong Kong, we're certainly hoping that that will have this in effect. I am now at -29, so I will wrap up. And there is fortunately not much more for me to say apart from to say thank you to Matthew for this canter through these topics. We hope it's been very interesting, and thank you for paying attention.
Thank you very much.
Thank you for the insightful exchanges. Would Dr. Dingsi and Mr. Townsend please move forward for a quick photo? Yes, please move forward. Come to the front of the stage for a group picture. Yes, please stay for a group picture. A big smile. Thank you very much, and please take a seat. Thank you so much. The panel discussion on experience sharing of the practice of arbitration funding in major arbitral jurisdiction will start in 3:15 p.m. So don't miss the chance to visit the exhibition booth set up for the first time during the Hong Kong Legal Week on the new developments and opportunities of legal services in Hong Kong, Macau, and the 9 mainland cities in the Greater Bay Area located opposite to this hall at room number N206 to 208. So we can now take a break, so do remember to come back at 3:15. So please take your valuables with you whenever you leave this hall. Please enjoy the refreshments in the designated areas outside the hall and return here before 3:15. 3:15. For online participants, we will see you shortly after the break. Thank you. Ladies and gentlemen, our event is about to start, so please take a seat. Thank you. Ladies and gentlemen, welcome back to our next panel discussion on experience sharing of the practice of arbitration funding in major arbitral jurisdiction. There will be a Q&A session after the panel discussion. For participants in the hall, if you have any questions for our panelists, please scan the QR code as you can see on the side. Yes, please scan the QR code. And without further ado, may I invite you, our moderator, Ms. Kim Rooney, a round of applause. And our panelists, Ms. Catherine Sanger, Ms. Sheila Ahuja, Mr. Cameron Hassel, Mr. Rory McAlpine, and Mr. Chao Li Jun. Ms. Rooney is the independent arbitrator and member of the ICC Court of International Arbitration. Ms. Rooney, the floor is yours, please.
Thank you very much. Dear guests, ladies and gentlemen, it is a pleasure to be here today with you and our panel during Hong Kong Legal Week 2023 to discuss with you arbitration funding, focusing on the legal regimes for outcome-related fee structures agreed by lawyers with their clients in 5 jurisdictions: Hong Kong, Singapore, Australia, England and Wales, and mainland China, as you know, 4 common law jurisdictions and 1 civil law jurisdiction. We will also discuss third-party funding of arbitration and briefly refer to arbitration expenses insurance, as these form part of arbitration funding available in Hong Kong and many other jurisdictions. In furtherance of Hong Kong's commitment to regularly updating its arbitration regime and ensuring that the arbitration law reflects best international practice tailored to Hong Kong's needs, since 2013, Hong Kong has regularly updated its arbitration funding laws in consultation with the arbitration community and the public. The provision of arbitration funding with appropriate safeguards in the public interest provides access to justice, as well as a financial tool for parties and our lawyers. Hong Kong's reform of its arbitration funding laws has been needed because the ancient doctrines of champerty, maintenance and barrenetry still apply as torts and crimes in Hong Kong. By contrast, for example, the England and Wales where it was abolished, or these were abolished in 1967, and to mainland China where no such common law doctrines apply. Hence, in 2013, the then Secretary for Justice and the Chief Justice requested the Hong Kong Law Reform Commission to review and make recommendations as to whether Hong Kong law needed to be reformed to allow third-party funding for arbitration. This followed the Court of Final Appeals 2007 judgment in Unruh and Seeberger, where it left open the question of whether third-party funding of arbitration was then permitted in Hong Kong. I had the honour and pleasure of chairing the Law Reform Commission's subcommittee on third-party funding for arbitration. In October 2016, following consultation with the public and a consultation paper recommending reforms to allow third-party funding of arbitration, the Law Reform Commission's final report was published with draft legislation which formed the basis for the amendments in Part 10A of the Arbitration Ordinance to clearly allow third-party funding of arbitration, emergency arbitrated proceedings, mediation, litigation under the Arbitration Ordinance. And in 2019, these reforms came fully into effect with a light touch regulation by a code of conduct. Now, there's a slide that will be coming up which just refers to a key point about third-party funding arbitration, which is third-party funding funding of arbitration provides funding to a party to an arbitration where the funder will receive a financial benefit only if the arbitration is successful within the meaning of the written funding agreement. The next step was to review and make recommendations as to whether lawyers should be permitted to offer outcome-related fee structures to clients. As Kath Sanger, the co-chair of the Law Reform Commission's OFSA subcommittee will discuss with you in more detail, on 16 December 2022, Hong Kong's law was amended to allow lawyers to offer to their clients outcome-related fee structures. Now, Hong Kong is not alone in offering these kinds of structures and third-party funding of arbitration, as you know. Arbitration funding is now permitted in most international arbitration centres in the world. However, different jurisdictions, common law and civil, have adopted different models for arbitration funding. We are indeed fortunate to have an experienced and international panel to share with us how the arbitration funding regimes work in their jurisdictions. Now let me, in the 2.29 or 2 minutes 29 seconds left, tell you what's going to be discussed today. Our session is divided into three main parts. The first of 30 minutes will address arbitration refunding regimes in these 5 jurisdictions of Hong Kong, Singapore, Australia, England and Wales and China, focusing on OFSA. First, Kath Sanger will provide an overview of Hong Kong's reforms. Kath Sanger is a partner of Herbert Smith Freehills. She was the co-chair of the Hong Kong Law Reform Commission Subcommittee on Outcome-Related Fees for Arbitration, and is a member of the OFSA and TPFA advisory boards. Kath Sanger's presentation will be followed by presentations from our other 4 colleagues. Sheila Ahuja is speaking about Singapore. She's a partner and head of Allen & Overy's Singapore International Arbitration Practice and co-head of the firm's India Group practice. Cameron Hassel, speaking about Australia, is a partner with Clifford Chance in Hong Kong and Australia. He maintains practices in and travels between those 2 jurisdictions on a regular basis. Rory McAlpine, speaking about England and Wales, is head of Skadden's Asia-Pacific Arbitration Practice, which he's been since 2013. He's the chairman of the ICC Hong Kong National Arbitration Committee, or Group Committee, I should say. Cao Li Jun, speaking about mainland China, is a partner and co-head of the Dispute Resolution Department of that firm. Now, among the topics our speakers will address in their presentations are what OFSA is permitted in their jurisdiction, which lawyers can offer it, whether there are caps on OFSA, who regulates it, and what the role of the courts is. In the second part of the session, which will take about 45 minutes, there will be specific topics addressed, including approach to structuring and pricing ORFSA, how to use it with other arbitration funding, termination and consequences, effects of non-compliance with applicable regulatory regimes, and cross-border issues, including staffing across offices, and finally, trends. Well, I have 15 seconds left to tell you that the third part of the session will last 15 minutes. It's a question and answer session. We hope that we'll hear from you with your questions, observations. Thank you for coming today and joining us to discuss arbitration funding. And now Kath Sanger will speak with us about Hong Kong's reforms. Thank you.
Thank you, Kim. I'm glad to see the 8 minutes doesn't start running until you actually arrive at the podium. Guests, ladies and gentlemen, as Kim said, it's really great to be here. We're day 3 of Hong Kong Legal Week 2023 to have an opportunity to talk about arbitration funding. As those of you who will have heard me talk on this topic before, as co-chair of the subcommittee on the reform, then you'll know that this is a topic which is important to me and increasingly close to my heart. Over the past decade, I think it's fair to say that the legal landscape has shifted in many jurisdictions, and you'll hear from experts in those jurisdictions today, allowing for more innovative ways of providing legal services, particularly in arbitration. And here in Hong Kong, as Kim said, the landscape changed just under a year ago on the 16th of December 2022, when the law was amended to allow lawyers to offer fee structures for arbitration and arbitration-related court and mediation proceedings based on the outcome or the success of the particular matter. Now, I'm genuinely proud of the reform that we've achieved. I think, hand on heart, we can say it's one of the broadest and the most flexible regimes in the world in terms not just of the types of fee structures that are available, but also the flexibility around the ability to define what success means to the parties to that particular matter. Anecdotal evidence tells me, and people have told me, that parties are choosing Hong Kong as a seat for arbitration, are choosing to switch general terms from Hong Kong court to Hong Kong arbitration precisely because of this ability to create bespoke pricing structures that best suit the matter and best suit the parties' risk and, of course, their reward appetites. This flexibility allows stakeholders to structure also the best pricing arrangements to allow them to collaborate with or complement the practices of lawyers in other jurisdictions, including the mainland, and that is increasingly, again, important. I like to think of it in blood donor terms. Hong Kong is what I call the universal recipient. It's the AB blood type. It can accommodate pricing structures from any other jurisdiction, and that should not be underestimated. And by the same token, lawyers, and by lawyers I mean barristers, as well as solicitors and registered foreign lawyers, can enter into OFSA in relation to arbitrations where the place of arbitration is not just inside Hong Kong, but also outside. And we'll talk a bit more about this cross-border flexibility during the session. Historically, these types of structures, and we call them Hong Kong outcome-related fee structures, and Peggy at lunch said to me that word structures actually was important, and I had not realized that until today, because that word structure gives you that sense of being able to build something which is bespoke. It's not just a pricing arrangement. But historically, it's been used as a way of allowing impecunious clients to have access to justice. And to give you an example, we are acting on an arbitration at the moment in my firm when we represent a family-based company that doesn't have very much money, but it has a very, very strong case against a big corporation. And we've been able to take that on a full contingency. We have insurance backup, and we'll again talk about some of these tools later. But we've been able to allow that company to access that arbitration, and it also allows us to build very strong relationships with that client as we go. But of course, in practice, these funds, these structures are not just about access to justice. Increasingly, clients use them to manage the costs associated with disputes. And this includes solvent businesses who can use these innovative structures to deploy cash elsewhere and share risk and reward with lawyers along the way. And this concept, as I said, of sharing risk and reward is very, very important. It gives clients the options of sharing with their lawyers the inherent risks of any form of arbitration proceeding. No matter how strong your case, you can never give it a 100% guarantee. A client asked me this morning, can you tell me 98% we're going to win? And I said, if you can find a lawyer who tells you that, then you may have to switch. But as quid pro quo for sharing those risks, then of course clients also share the rewards of those particular mandates as well. And these are key components of the reform in Hong Kong, and they bring Hong Kong squarely into line with other jurisdictions. There are three types of structures. You'll have heard us talk about this. We have the conditional fee agreement, and that's where a client agrees to pay a lawyer a fee, a success fee, which is benchmarked against normal or regular fees, and it's often described as a percentage of the benchmark fee. There are caps. Hong Kong follows the approach in England and Wales. You hear Rory talk about this, where these types of structures have been working well for many years. The success fee uplift cannot exceed 100% of benchmark. So in very simple terms, a lawyer cannot charge more than 2 times the regular fee as a reward for winning a particular mandate. Then we have a DBA. This is more like a contingency arrangement called a damages-based agreement, where the lawyer and the clients structure what's called a DBA payment calculated by reference to any financial benefit obtained by the client in the arbitration. Now, typically, of course, this will be an award or even a recovery of damages, but the definition of financial benefit in the ordinance is extremely broad and allows it to be tailored really to any type of matter, to any type of claimant or respondent, and to any type of dispute. There is a cap again, and lawyers cannot charge more than 50% of the financial benefit as the DBA payment. The hybrid DBA is the third type, and really that's the most interesting development and where I can genuinely say that Hong Kong is leading the way. And a hybrid is where the lawyer charges some fees, typically discounted during the life of the matter, plus a DBA payment if the client obtains a financial benefit. And these types of structures are really, really useful for the full of more long-running, complex type of arbitrations where it's, of course, difficult for lawyers to take this on with no cash flow whatsoever, but you can structure it where you get some cash flow, but then have a financial benefit DBA payment at the end of the matter. In terms of the structure, as Kim mentioned, Part 10B of the ordinance sets out the framework and operative sections, the rules. The safeguards are in binding legal rules, and that's in the CAP 609D that contains the specific general and special conditions that apply to the structures. And the reason for this was to provide adequate safeguards, we thought, not just for clients, but also lawyers as we navigate this new regime. I don't have time to go through all the conditions. There is a checklist that's coming, and the DOJ will talk a bit more about this later, that will give some guidance to parties using these structures. But in basic terms, they need to be in writing. There needs to be at least a 7-day cooling off period. You need to describe what success means and how that payment will be calculated, and you need to provide for termination. And we can go through that in a bit more detail later. And as I said, this might sound a bit daunting. The rules are deliberately short, they're deliberately succinct, and that was intended. The DOJ, working with both the Law Society and the Bar, have already produced funding options and a top 10-20 FAQ. And as I've said, there's additional guidance and a checklist coming. Watch this space on the DOJ website today. And this is just the first step. So I'm really excited about today's panel. I've got 2 seconds left. We're really grateful to have what is a really excellent team of experts to talk about their respective jurisdictions. Thank you.
Thank you. Thank you very much, Kath. So now, ladies and gentlemen, we're going to move on to a summary of arbitration funding regimes in Singapore, Australia, England and Wales, and mainland China. So may we invite Ms. Sheila Ahuja to talk with us about Singapore. Thank you.
Thank you. Thank you, Kim. And it's a real pleasure to be back in Hong Kong here for Hong Kong Legal Week. Some of you may know that I'm originally from Hong Kong, and 5.5 years ago I relocated to Singapore. So when Kim called me and said, would you mind coming back to Hong Kong too? I didn't wait for her to finish the sentence, and I just said yes. And then she told me about the topic and then left me to study for the rest of the 2 months notice that she gave me so I could come up here and say something semi-articulate. What I'm going to do in my 3.5 minutes is set out the Singapore funding regime. You've heard Kath talk through the Hong Kong regime. The time period in which Singapore implemented its funding-related legislation and regulations is pretty similar to Hong Kong. I have twin girls, and I'd like to think that they operate the way that Singapore and Hong Kong sometimes do, which is they'll have a very similar objective. They'll have different plans and go about it different ways, and both will be really interesting and entertaining, and both will be very much talked about by the end of it. In the case at home, though, they often don't get what they actually ask for at the end. Anyway, in Singapore, the first step, just as was the case in Hong Kong, was to abolish the torts of maintenance and champity, as Kim introduced up front. And Singapore did this in 2017 by amending its Civil Law Act. Since then, there have been 2 ways in which proceedings can be funded. The first is third-party funding, and I'll address this very briefly because our focus is more ORFSA. Third-party funding was achieved in 2017 or introduced into Singapore by amending the Civil Law Act following the introduction of the Civil Law Third-Party Funding Regulations. ORFSA then came some years later, last year, in fact, into Singapore in 2022, where Singapore amended its Legal Profession Act, the LPA, by adopting a legislation called the Legal Profession Amendment Act of 2022. It then supplemented this statute with some regulations, the Legal Profession CFA, Conditional Fee Arrangement Regulations, and this really sets out the scope of the ORFSA scheme in Singapore, which I'll introduce briefly. And then there's a guidance note issued by the Law Society of Singapore that provides best practices for those who want to enter into CFAs, and also provides a sample CFA, actually, for you as a starting point. The point is that each of these 2 regimes has its own requirements and safeguards, and just as Kath set out the requirements for a Hong Kong CFA or outcome-related structure, likewise, Singapore has some criteria that you need to be sure to satisfy for that scheme to be recognized. So the types of cases that are covered for ORFSA are international and domestic arbitration proceedings, both in Singapore and outside. Proceedings that are commenced in the SICC, that's the Singapore International Commercial Court, and that's not transfer cases, so cases that are originated in the SICC and remain in the SICC. Arbitration-related court, as well as mediation proceedings. And also it covers work done in and around those proceedings. So for instance, preliminary advice, negotiation and settlement steps, even if the proceedings didn't actually happen. So what is permitted as a matter of ORFSA in Singapore? It's CFAs, so no win, no fee, or no win, less fee, and we'll talk a little bit more about that. DBAs are not permitted, so they're strictly and expressly prohibited under Section 115B4 of the LPA. So those are not allowed to be, unlike Hong Kong, entered into in Singapore. And the concern around this that the Singapore government had is that payments under such DBA arrangements don't have a direct correlation with the legal work done and could give rise to risks and conflict of interest. Now, I mentioned the requirements as to form. I won't go into the detail of that. As to which lawyers can enter into ORFSA, it's both Singapore qualified lawyers and registered foreign lawyers in Singapore, and the LPA provides that. And at the same time, those lawyers need to comply with their professional conduct rules as well. Just 2 more points from me. One is that there are no caps. Some jurisdictions have caps on the uplift fees. In Singapore, there aren't. But the guidance suggests that, A, the Minister of Law may impose as a matter of practice certain caps, but that hasn't happened to date. And of course, the fees charged have to be subject to a reasonable test, and that's to be assessed on a case-by-case. And finally, there is a role of the courts, which is to make sure that these CFAs are valid and effective, and finally, to discipline lawyers who don't comply with these rules. And again, that's something we might cover later. Thank you very much.
Thank you very much, Sheila. Now, Cameron, can you speak with us about the Australian regime for OFSA? Thanks so much, and arbitration funding.
Thank you, Kim. I'm here, as Kim says, to discuss the position in Australia. Australia is actually one of the pioneers for funding, litigation funding. In fact, I recall when I started practicing in the late 90s, seeing billboards around sort of more industrial areas in Sydney, lawyers advertising no win, no pay for personal injury cases, and that's still very prevalent today. There are essentially two types of litigation funding in Australia. There is funding agreements now with third-party litigation funding companies, so, and you've heard Kath and Sheila both talk about that. And then there are conditional fee arrangements between clients and lawyers. Law firms and Australian lawyers are not permitted to use DBAs or hybrid DBAs for arbitrations seated in Australia or in respect of Australian litigations, with limited exceptions in the Victorian courts for class actions. So similar to what you just heard from Sheila in respect of Singapore in relation to DBAs and hybrid DBAs. And indeed, the reasons for that are, as Sheila has discussed, in Singapore in relation to potential conflicts for interests and aligning the remuneration of the law firm with the work that they do. So slight difference as between at least Australia and Hong Kong there. However, the prohibition against these DBAs, hybrid DBAs, bites on law practices in Australia and Australian lawyers under our Law Society rules. And so I think in theory it is possible, I won't go any further than that, possible that non-Australian firms with no practice in Australia and utilising lawyers who are not Australian qualified might be able to conduct arbitrations in Australia and use DBAs or hybrid DBAs, provided that that arrangement is permitted in their home jurisdiction as it is here in Hong Kong. So that'll be an interesting one to see, but I do think that that is at least possible. And then the other point to note here is that third-party funding companies, so as distinct from lawyers, are permitted to use DBAs and hybrid DBAs in their arrangements. So the prohibition is against lawyers in Australia, as I say. Turning briefly then to conditional fee arrangements with the lawyers, very similar to what you've just heard from both Sheila and Kath as to how they work. Can be no win, no pay, or partial win uplift type arrangements. There are various requirements. Briefly, the agreement has to be in writing, signed, and in plain language, has to set out the circumstances which constitute a successful outcome and therefore in which the uplift fee can be charged. There needs to be in the agreement the ability and understanding of the client that it can seek legal independent advice in relation to the agreement. It has to contain a cooling off period of not less than 5 business days, and probably most critically, and again this differs somewhat from the position in Hong Kong, the uplift fee cannot exceed 25% more than the benchmark. So rather than double, it's only 25% more that is permitted in Australia. And again, the same rationale applies so as to try and minimise the scope for conflicts. Final point, DBA and hybrid DBAs for Hong Kong seated arbitrations. Australian qualified lawyers can agree DBAs, hybrid DBAs, for work on a case that's seated in foreign jurisdictions, including Hong Kong now, that allow for such arrangements, provided, of course, that they comply with the local rules.
Thank you very much, Cameron. So now may we, thank you, Cameron. Now may we invite Mr. Rory McAlpine to speak with us about the regime in England and Wales. Thank you, Rory.
Good afternoon. When I first rocked up in Hong Kong, I was somewhat taken aback to learn that lawyers were being prosecuted for entering into fee arrangements which involved taking a piece of the action, no pun intended. That was all the fault of those 13th century English bogeymen, Messrs. Champerty and Maintenance. And as you've heard from Kim and from Sheila, the continuing influence of those prohibitions held back until very recently the development of fee arrangements in Hong Kong and Singapore. Innovators like Kim and Kath, the architects of the fee reforms in arbitration, have had to navigate their way around those restrictions. Until the end of the 20th century, England, like Hong Kong, embraced a traditional approach and was resistant to any suggestion that the funding of lawsuits might be made more innovative. But once the penny had dropped, the landscape in England meant that it was much easier to introduce the necessary reforms than it has proved to be in Hong Kong and Singapore. And again, that was because very conveniently over 50 years ago, in 1967, during the Summer of Love, as it became known, Champerty and Maintenance had been abolished by specific legislation. So alternative fee arrangements in England are longer established than in Singapore and Hong Kong. I want to make two other high-level observations. First, there was a huge political imperative to introduce alternative fee arrangements in England, and to do so quickly. And that was because until the 1990s, the court system was positively awash with government-funded legal aid. When that came to a rather abrupt halt for political and economic reasons, something had to fill the access to justice vacuum. And it's therefore no coincidence that the outcome-related regime in England applies universally to litigation and arbitration across the board and is in many ways more attuned to the needs of litigation. In other words, it's the very antithesis of the position in Hong Kong. I want to cover very briefly the three pillars of fee structures in England with a focus on arbitration. And those are all concepts with which if you weren't familiar previously, you're now very familiar by this stage of the afternoon, namely CFAs, DBAs, and if you like, bog standard or mainstream third-party funding. And there are only two things I want to mention about CFAs in England. The first is that, as in Hong Kong, the uplift element can't exceed 100% of the normal fee. In other words, the lawyer is subject to a restriction whereby, if successful, he or she can only double their money. Moving on to DBAs, they are of more recent origin in England. They've been around since 2013. Again, there's a limit on the extent to which the lawyer can hit the jackpot. For business disputes, that limit is 50% of the financial benefit obtained by the client. I just want to say something very quickly as the clock runs down about litigation funding or third-party funding, because 3 months ago there was a landmark decision of the UK Supreme Court in a case called PACCAR. The outcome of that case has provoked a certain amount of panic in the third-party funding industry. Suffice it to say that the highest court decided very unexpectedly that third-party funding agreements fell within the definition of DBAs. That took the industry as much by surprise as anybody else. And suffice it to say that furious renegotiation of those sort of arrangements is now vigorously underway. Thank you.
Thank you very much, Rory. And now our final jurisdiction review is by Mr. Kali Jun about mainland China. Thank you very much.
Thank you, Kim. I'm the only representative from mainland China and the civil law jurisdiction. Let me start by saying in China, in mainland China, third-party funding is not a problem. We do not have concepts such as champerty and maintenance, and there's no rule against such arrangement. So I will just focus on funding by lawyer or law firms. There is no specific regime for arbitration funding by lawyer law firms. The issue is to be examined from a more broader perspective, namely how lawyers are going to charge for their work, their legal services. There are a number of regulations starting from the 1990s, but the current most recent ones are the one called Opinion on Regulating Legal Fees, which were issued in 2006 by MOG, Ministry of Justice, and the National Development and Reform Commission, NDRC. The other one is more recent. It's called Opinions on Further Regulating Legal Fees. It was issued in 2021 by MOG, NDRC, and State Administration on Market Regulation. You may wonder why NDRC is involved every time. This is because NDRC was previously known as a planning commission. It contained a department called the Pricing Bureau, which basically regulates the prices for all the merchandise and the services in China. According to the 2006 regulation, lawyers can charge fees either according to the number of cases. This is only for small cases that do not necessarily involve financial benefit, or by a percentage. This means it's larger cases involving financial benefit. They can also charge by time. But our tradition is not to charge by time or hours. Our tradition is to charge fixed fees. You think about the charge by number of cases or charge by a percentage of the amount in dispute, it's all about fixed fees. Under 2006 regulation, there's a provision on what is called 风险代理费用, or risk management or representation charge or fee. In my view, this is a variant of the fixed fees. The risk management fee can be either a fixed amount or percentage of the financial benefit to be obtained. If the financial approach is to be adopted, it's subject to a cap of 6 to 18% of the financial benefit, depending on the scale. Previously, under the 2006 regulation, it's a 30% cap, so it has been lowered down under the 2021 regulation. There are a few exceptions to the general rule where the lawyers can charge risk management fees. Those exceptions are important. They include criminal litigation, administrative lawsuit, state compensation lawsuit, class action, personal injury compensation, and labor remuneration. You can see the policy considerations behind those important exceptions. Compared with OSFA here in Hong Kong, it's difficult for us to categorize even the risk management fee as a CFA, DBA, or hybrid DBA. In my practice, the most popular fee charge arrangement would be a fixed amount which are paid upfront, plus a percentage of the financial benefit as risk management fee. This is, in my view, a bit similar to hybrid DBA. I have also done a few cases in which the upfront fee is based on hourly rates but subject to a cap. Again, I think it's a variant of the approach that I just mentioned. As an arbitrator, I have the benefit of seeing how other lawyers charge for their fees. So in my experience as an arbitrator, I have never seen any Chinese lawyer charge the CFA, But some lawyers may charge a DBA, meaning there's no upfront fee, and their fees are only based on the amount they are going to win through the arbitration. So I think I better stop here. Thank you.
Thank you very much. Everyone's done a wonderful job covering complex topics in a very short time. But ladies and gentlemen, we really want to give you a chance to ask questions, comments, so we'll keep moving on to part 2, which is discussing specific questions. And so we're going to start first with the approach to structuring fees and compensation. And so in the first part, Kath Sanger and then Carly Jun will speak generally. So Kath, could you please outline the approach to structuring OFSA for a Hong Kong-seated arbitration, including the approach to pricing? Thank you.
Thanks, Kim. Obviously, each case and each client is different. The way we look at it internally as a law firm is, first of all, when we're giving a sort of pricing proposal to clients, we try and give as many options as possible. So thinking about, as Sally Jun said, maybe there's a fixed fee, maybe there's an hourly rate, but now we are adding in, or trying at least to think about adding in, an officer type proposal. Clients, we know, like options when it comes to pricing. There's a thinking that actually from a professional ethical perspective, you need to give clients an offer of what is available. But you need to understand each client is unique, each case is unique. I sit on the firm's we have a newly established success fee pricing committee. It's a global committee, and often when we are looking at approving success fee arrangements, we would like to see at least some form of merit assessment. So often you have to think about, as a lawyer, is this case likely to win or is it likely to lose at a much earlier stage perhaps, and in some cases being dependent on the information the client is giving you. But we know that clients are coming to ask us for these types of arrangements. Financial institutions are very savvy. The banks want to see it. And of course, as Sally Jun said, Chinese clients are used to using them in the mainland and like now to see it happening in Hong Kong. What I will say is that we are really doing mostly CFAs at the moment. I think that's consistent across the board. When we see notifications and we understand what our colleagues are doing, starting small, the benefit of having a flexible system is that it doesn't have to be big ticket stuff, so we can have incremental uplifts across a range of different outcomes. And we are even, for example, when you're on a discounted fee anyway, saying to the client, we'll stay with our discounted rates, but if we are successful, then you will pay us up to benchmark. And that's not an uplift in the traditional sense, but it does give lawyers and clients the ability to have these discussions. And clients are much more financially savvy than we are, frankly. And if you don't have those discussions, sometimes they want to know why.
Thank you. Now, Li Jun, could you share with us what the most common types of OFSA in mainland China for a Hong Kong-seated arbitration are and how they're priced?
We do a lot of Hong Kong arbitration. Basically, we have two types of a fee charge arrangement with the clients. First one is the most preferred. It's basically charged on hourly rate basis. But sometimes the Chinese client tends to prefer to have a certainty or predictability over the fees, so we come up with a fee estimate, and if fee estimate is not acceptable, we come up with a fee cap. Now that Hong Kong allows the CFA, maybe in the future we can be creative, and we ask our Chinese client to also agree with us to uplift our whatever has been capped if we win the case. The other more popular option is, as I mentioned, upfront fee plus, a percentage, which is deemed as a risk management fee. This is what we typically charge for Chinese clients in China onshore work. For Hong Kong work, they also tend to or prefer such an arrangement. But compared with what we have done in mainland China, our fee charge, there are some differences. Particularly the upfront fee tend to be higher, and the percentage of the benefit tend to be lower. That's what I typically see in our cases. Thank you.
Thank you. And then staying with these two colleagues, maybe ask you, Li Jun, how are OFSA structured for a Hong Kong-seated arbitration where a mainland Chinese firm works with a Hong Kong barrister, please?
it's true that we are faced with Hong Kong arbitrations which may be governed by Hong Kong law, very likely. In those situations, we have to work either with Hong Kong solicitor firms or Hong Kong barristers, or both. But more frequently, in recent years, we are instructing Hong Kong barristers, deeming ourselves as a solicitor firm. So far, the fee charge, the Hong Kong barrister or solicitors, in my cases, they basically all charge on hourly basis. I have never done a case in which they charge CFA or DBA, but I think the reason is because OFSA just came out a year ago, and people need time to get adjusted to it. So I asked a few friends, Hong Kong barrister friends, whether they are willing to accept such an arrangement. They said basically they are open-minded to it, and they are willing to accept it if the case is appropriate. For us, the real difficulty is this. Because we charge upfront fee plus percentage. So, but we pay, if the barrister or Hong Kong solicitor, they are charged by hours, we need to be sure whatever we have collected upfront are sufficient to cover Hong Kong lawyers' fee charged by hours. So that's a real challenge. That depends on good assessment of the matter, the ability to negotiate for a good upfront fee, and evaluation of how much work, how much hours have to be spent by the Hong Kong barrister. So that's, I mean, if CFA and the DBA are popular and acceptable to Hong Kong lawyers, barristers, this will make our work much easier, and hopefully our life much easier.
Thank you very much. And now, Kath, is there any difference in approach where a Hong Kong-based firm works with a Hong Kong barrister using OFSA funding? Thank you.
Thanks, Kim. I mean, just 2 points of context. The first is that there's always been a big question as to whether barristers will take up these sorts of fees, bearing in mind we're talking about arbitration and not court proceedings. But the Hong Kong Bar Code actually already permitted barristers to do success fee structures where that was permitted in an overseas jurisdiction if that was where they were operating. So in fact, it's less new to the bar than it is potentially to the lawyers. I've heard anecdotally that given that in arbitration, again, Chinese clients and Chinese law firms can instruct barristers directly, and we see that that structure quite commonly from the other side of the table. We know that some Hong Kong barristers have agreed to take matters on a DBA basis, so that's a real question mark. From our perspective, I think it depends on when a barrister is brought in, because if a barrister, they say to me, if we're brought in later in the proceedings, then it's probably more likely that they'll be on a disbursement basis, so their fees will be paid irrespective of the outcome, and that's something that the rules requires the parties to state specifically in their OFSA agreements as to how barristers' fees are to be treated. But I think it's really a question of watch this space. This is arbitration. The barristers that work in arbitration tend to be at slightly more innovative at the forefront of things. And frankly, anything I think is going to be possible. It's a question of watch this space as we move forward.
Thank you very much. Now, moving on to the next part, which is asking Sheila and Cameron to speak with us about using OFSA with TPFA and arbitration expenses insurance. And first of all, Sheila, how is OFSA typically used with TPFA and arbitration expenses insurance in your experience? Thank you.
Thanks, Kim. I think dealing first with OFSA and TPFA, so outcome-related and third-party funding, there isn't, as far as I'm aware anyway, any restriction with using them together. So you can be quite creative and give the client more choice and flexibility by saying we can do OFSA as well as talk to a funder at the same time. And of course, we know the choices of third-party funders in this market have also had a really big boom. In terms of arbitration expenses insurance, so what OFSA and TPF does is it funds the litigation costs during the proceedings, but it doesn't fund the legal costs of opponents where those proceedings are unsuccessful. And that's where after the event insurance, so ATE insurance, comes into play. And it indemnifies essentially the policyholder litigant and helps cover the opponent's legal fees and disbursements, and sometimes one's own disbursements as well. And Kath mentioned insurance at the beginning as well as a product that is now being explored. I think in Asia, it's probably fair to say that in other parts of the world, this was available a while ago, and it's coming into Asia as of more recently. But it is a very effective tool, I think, to look at where one is looking for risk transfer or stability on the balance sheet, and also, of course, but not always actually, as a means to try and defeat security for costs. But this is on a case-by-case basis, I should caution. There are various users of ATE insurance, so litigation funders themselves look at this as an option, insolvency practitioners, corporate clients, and the like. So in essence, you can use sort of AT insurance alongside ORFSA and TPF to finance and insure costs from the proceedings and costs arising from the outcome. So essentially the full cycle. And sometimes it's provided separately and sometimes together. Of course, depends on how you package it. Of course, the pros are you can risk manage, and I think in addition to the actual management on your side, if the other side comes to know, if you're willing to disclose the fact of this arrangement, what we've seen is sometimes it's an incentive for the other side to come forward and settle because they know that your risk appetite has been managed where perhaps theirs hasn't been. The disadvantage, though, is that sometimes these products are expensive. And they may not be sufficient, to my point earlier, about actually being able to defeat security for costs, and it depends on the terms of the policy and the circumstance of the case, and potentially the forum.
Thank you very much. And Cameron, what has been your experience of using ORFSA and or TPFA, whether together or apart? Thank you.
Thanks, Kim. I'd say as a high level, varied, generally positive, useful for some but not all cases. So I'd sum it up. So, for example, taking up Sheila's point on ATE, we have looked at that recently for a case in Australia, but it was very expensive. And so the client elected not to take that up, and that was in and of itself. So I accept and agree with Sheila's point that it can be quite expensive. For conditional fee agreements, I used one very recently in Australia, a litigation. In fact, we settled a week and a half ago, and that was a positive outcome both for the client and I'm happy to say for us as well. So that that has been useful. I've got a litigation and an arbitration going in Hong Kong at the moment, both with conditional fee arrangements in place. So you're seeing clients ask for it, and to Cass' point, we will, like Cass' firm, offer it up quite often, depending on who the client is and whether we think that sort of option will be well received. Not well received by all clients, but some like that optionality. Third-party funding, you've used it in a CTAC case, and interestingly enough, the opposing party challenged the use of funding in that case and then took it to court and failed in their challenge to the award on the basis that we had used funding, which we disclosed up front. And they also complained to CTAC about that, and CTAC dismissed that complaint as well. And I've used it in Hong Kong, seated arbitrations. What I haven't, like Kath, seen much of yet, at least within our firm, is no win, no pay arrangements. As I say, in Australia at least, that's more for the sort of what some would call, not necessarily me, personal injury lawyers, ambulance chasers. That's very common in that space, not so much in the commercial space, but there will be, and Kath's given an example, there'll be examples where it's good to use.
Thank you very much. And staying with Cameron and Sheila, we now turn to termination and its consequences, termination of the ORFSA agreement. Cameron, could you please explain the legal framework for terminating ORFSA before the funded matter has concluded in Australia, please? What are the legal consequences?
Well, as I said when I was at the lectern, there are various requirements that must be set out in the agreement, and provided that you've met the agreement, then the terms of the agreement will apply. So if the client terminates, typically, subject to the terms of the agreement, the success fee or some portion of it will be payable. However, there is the 5-day cooling off period, and the success fee will not be payable if the termination occurs within that cooling off period.
Thank you. And Sheila, what is the legal framework for termination of an officer before a funded matter has concluded in Singapore? And if you have time, in England, please. Thank you.
Thanks, Kim. So I think in Singapore, very similar to what Cam said, and both Cam and Kath mentioned the cooling off period, which is also a criteria for CFA in Singapore. So within, and the regulations provide for this, within the cooling off period, there's essentially from the time you enter into an ORFSA, there's a 5-day cooling off period, just as Cam said for Australia. But if you vary the ORFSA at some point down the line, then the cooling off period comes back, and this time it's 3 days. So of course, during that period, client can walk away and it isn't liable for any sort of costs or payment unless, you know, you've sort of, unless there's some exception to that. Outside of that cooling off period, it's then governed by the contractual terms, just as Cam said as well for Australia. The CFA guidance, so the Law Society guidance that I mentioned earlier in Singapore, does recommend certain provisions and best practices that termination clauses should expressly provide for cost consequences, so basically asking you to set it out quite clearly and expressly. Mutual termination clauses to be drafted in to provide for termination outside the mandated cooling off period, so again, mutual termination rights and put them in there expressly. And that practitioners leaving for another law practice should enter into a new CFA with the client. Again, I think that gives a lot of foresight into factual scenarios. Just briefly, I guess in 30 seconds in England, there's bespoke rules for different scenarios, but there's a model CFA as well, which is intended to be, I think it's in the process of being updated, but that provides a 14-day cooling off period where there's a right to cancel the agreement, and the charges are to be paid if the agreement is ended before the client wins or loses. And again, conditions that may trigger termination that should be provided for, and you can find them in that model. So that's.
Thank you very much. So now, in this section, we're moving on to the effects of non-compliance with applicable regulatory regime. And so Rory and Sheila are going to speak with us very quickly about this. So Rory, what are the consequences under Hong Kong law of failing to comply with the ORFSA provisions, please?
Well, as far as I'm aware, there's no straight answer to this question. To the extent there is an answer, I think it's to be found in a rather obscure and recently inserted provision in the Hong Kong Arbitration Ordinance. That provision is rather exotically named Section 98ZK, subsection 1, and the operative words state rather cryptically, an ORFS agreement for arbitration that meets the various applicable conditions is not void or unenforceable. That wording is challenging, but it's been widely interpreted as meaning that the other side of the coin is that an ORFS agreement which fails to meet the applicable conditions is potentially unenforceable. Presumably, the question of whether a breach of the conditions would result in the agreement being unenforceable depends on the severity of the breach or the level of culpability of the lawyers involved. As far as I know, there's been no decided case in Hong Kong. There was a decision about non-compliance in the English High Court in 2002, a case called Diag Human against Volterra Fietta. Volterra Fietta may sound like a low-cost Spanish budget airline, but is in fact a London law firm. Indeed, their website proclaims that they are the world's finest public international law boutique, and that the eponymous Mr. Vieta is, quote unquote, the greatest public lawyer on planet Earth. But they claimed the sum of £3 million under the provisions of a CFA. That was problematic because that involved an uplift of more than the maximum 100%. But that was the manner in which they conveniently documented the CFA. And the court took a very robust approach and insisted that literal compliance with the regulations had to be observed. So the unfortunate law firm recovered no fees whatsoever, but remain the world's finest public international law boutique.
Thank you. And Sheila, would you share with us what the consequences are under Singapore law of failing to comply with the ORFSA provisions or equivalent? Thanks.
So just two aspects there. First of all, in relation to the consequences of the CFA arrangement itself, the solicitor or foreign lawyer or law practice entity is not entitled to recover any amount in excess of the amount that would have been recoverable and would have to repay any excess amount received. And the remuneration and costs incurred or chargeable to contentious proceedings included in the agreement are recoverable as though there hadn't been a CFA. So essentially to revoke the consequences or reverse the consequences of the CFA. That's 115D5, not as exciting a clause number of the LPA. On the solicitors themselves, the consequences are that the court has the power to strike them off the rolls, suspend them from practice, issue penalties, censure them if they're guilty of a breach of professional conduct rules, which amount to improper conduct in practice. And that's under Section 83 of the LPA.
Thank you very much. So, ladies and gentlemen, now we're going to turn to discussing cross-border issues. Let's talk about cross-border issues where a party to a Hong Kong case wants to be represented by lawyers from offices outside Hong Kong and from offices in a jurisdiction where DBAs or hybrid DBAs are not permitted. And so Sheila and Cameron are going to start talking about this. And Sheila, could you comment, please, on the factors that you will think about when staffing a Hong Kong-seated case funded, well, where a client wants it to be funded by DBAs or hybrid DBAs with lawyers from other offices such as Singapore? And for those of us in Hong Kong, we'd be interested to know whether a similar approach is adopted to that of the Hong Kong Court of Final Appeal in Unra and Seeberger. Thank you.
Thanks, Kim. And this is a topic I really quite enjoy sort of grappling with, but Kim told me that if I exceed my time, this mic will self-destruct, so I'll try and keep it short. But Unra and Seeberger is a case that Kim, I know you've mentioned a few times and you know very well. I mean, I think para 122 of that case is really informative here, where the Hong Kong court basically says that it shouldn't strike down an agreement on the grounds of maintenance or champity where it is to be performed in relation to judicial or arbitral proceedings in a jurisdiction where no such public policy objections exist. It's basically comity and respecting the other jurisdiction and saying we're not going to stand in the way if it's allowed elsewhere. Public policy is the lens that it looks at it from. So that's the sort of overlay approach. But I think as practitioners, and I've set out sort of the consequences in some of these jurisdictions if you don't comply with these arrangements, I think the starting point ought to be a bit more conservative perhaps, and starting with prohibition and then looking at what arrangements are permitted. So essentially prohibited and less permitted rather than permitted and less prohibited, if you like. And what I would say about your specific example is, if there's a Hong Kong seated arbitration and there's a Singapore lawyer with a governing law of the CFA being sort of, say, English law, it's clearly relevant to what the governing law analysis here is and the different laws that come into play. But as Singapore would not accept, and a Singapore lawyer would not be able to enter into a DBA, we would say that the Singapore lawyer would be offending their professional conduct rules if they agreed to enter into a DBA, even if it was permitted in Hong Kong. So I guess just to wrap up the approach, there's a lot more to say, as I say, but just to wrap up the approach, there's different layers of regulations that could apply. You have the law of the professional regulation of counsel who's involved. You have the law of the seat or court, depending on if it's an arbitration or arbitration-related proceedings. You have governing law, but that means the underlying governing law of the contract, which I don't think is as relevant, but the law of the CFA or DBA arrangement, or the law of the engagement terms of counsel even. And we would say, and I would say, you look at it from a conservative lens to start with and see which one is the narrowest, I guess, or has the widest prohibition. But note that even though I say governing law may not be relevant and it's your jurisdiction's disciplinary rules that apply, actually, if the courts of the seat permit it and they're consistent with your jurisdiction of discipline, you may also have to think about at the time of enforcement, because it is a public policy lens, what is the law of the place of enforcement saying? And is that another layer that might create sort of problems as we've sort of seen and had to grapple with around the region?
So very complex, and one would have to analyse very deeply. So Cameron, turning to Australia, do similar considerations apply if you wish to staff a Hong Kong-seated case by a DBA or a hybrid DBA with Australian lawyers who are in Australia?
No.
No, and you'd already discussed that, right?
Yeah, that was my last point. That's not going to be a problem from an Australian law perspective.
Great. Well, thank you. So we're now moving on to the next part of this scenario, which is going to be addressed by Callie Jun and Rory McAlpine, and that's multiple firms barristers. So, Li Jun, can you comment from a mainland China perspective on the factors you'll think about, please, when staffing a Hong Kong-seated case funded by DBAs or hybrid DBAs with lawyers from multiple firms, or including where you've got barristers engaged?
Let me first say, on the way here, I read the Seaburger case, which is a very interesting case, and I realized it is related to another case, EcoSwiss versus Benetton. When we study the issue of arbitrability of antitrust disputes, that's an interesting case from the European Union. Well, for going back to the question that Kim just raised, I think the good news is China and Hong Kong both recognize the DBA arrangement. And would there be any problem? I think there are problems. I just realized when preparing for this seminar that the Hong Kong OSFA governs all lawyers doing arbitration in Hong Kong, including us. So we are bound by two sets of rules. One is from mainland China, for which we can only charge 6 to 18% as risk management fees. On the other hand, we are also bound by Hong Kong OSFA rules, which basically is 50% of financial benefit to be obtained. So when we are doing arbitration cases in Hong Kong, can we go for the the higher percentage? I think the answer is probably no, because if we charge 50%, we are risking violating the rules in China. There will be a compliance issue. And the other thing is, because we have a Hong Kong office, if we involve our lawyers from the Hong Kong office, I think I have one colleague here, are we able to go beyond 18% and charge 50%? I think as long as we are involved, there's still a compliance issue, so we need still to be conservative. The other thing is, from the commercial sense, if we charge on that basis DBA or hybrid DBA for up to 18%, but our the barrister we instruct in Hong Kong, they probably have to be subject to that cap as well. Because if they charge over 18%, that means we are running a loss for instructing Hong Kong barristers. So that's from the commercial perspective. Thank you.
Thank you. So Rory, what factors do you think about when staffing a Hong Kong-seated case funded by DBAs or hybrid DBAs with lawyers from multiple firms or where you instruct barristers? Thank you.
Thanks, Kim. I think above all else, the principal consideration one has to focus on is the maximum 50% of the financial benefit obtained by the client, and the fact that all services being provided on a DBA basis are subject to that cap and must be brought, as it were, under that umbrella. So that if, for example, one engages a barrister as part of the DBA, the barrister's fee, if the barrister is acting on a DBA basis, has to be brought within that limit. And again, if there's more than one law firm involved, the collective team is subject to that restriction. You can't cheaply circumvent this by entering into separate arrangements with all the different lawyers, with the individual stables of lawyers, if you like, involved in the team, because the overall maximum still applies. And of course, at the risk of stating the bleeding obvious, in cases where a more complicated arrangement of this kind exists, where there are multiple lawyers involved, the whole position and the whole arrangement has to be documented even more meticulously than usual, so that all the lawyers involved, as well as the client, know where they stand in every set of conceivable circumstances.
Thank you very much, and thank you to colleagues for so succinctly covering so much ground and so many complex issues. So now we're coming to, before we get to Q&A, Kath Sanger's comments on trends. Thank you, Kath. So we've had a broad-ranging discussion, just to set the scene for the participants perhaps, we've had a broad-ranging discussion about OFSA, touching among other topics on pricing, third-party funding for arbitration, arbitration expenses insurance, and regulatory issues, staffing across borders. Can you spot any trends? How is the use of OFSA likely to develop? Thank you.
Thanks, Kim. Not a difficult question at all. I feel like Sheila's left us with some alarming images of lawyers being locked up and getting this wrong. I would say that the rules we've made are, and hopefully with the checklist and the guidance that the DOJ will have available for you, but at the end of the day, gives lawyers and clients an easy rundown of what you need to think about to make sure you get it right. For anyone who's been watching the HSF blog, you may have seen that Mimi Chan recently, to put a bit more of a success story for lawyers at least, recently refused to uphold a challenge to a US award that was for the enforcement of a contingency fee for US lawyers. And just to give you an idea of the scale of the numbers in that, the contingency fee was $50 million US, obviously a very large scale that was permitted under the US rules and was upheld in Hong Kong, I think based on a monthly retainer of $600,000 US per month. But that's just to give, that there's lots of different things happening in different jurisdictions. What I will say is that we know from the HKSC that officers are starting to be notified. We have seen notifications from our counterparts, because under the rules, under the ordinance, you have to notify once an officer has been put into place. And we've seen those notifications come in arbitrations that were already on foot at the time of December 2022. So in effect, we know that pricing arrangements are being restructured by our fellow lawyers. There's one particular law firm, if you ask me later over a cup of tea, that seems to have put everything under an officer that we're opposite them at least. We know it's more likely, as we've said, to be CFAs. Obviously some of this is quite complex, and obviously the risks involved in lawyers taking on a full contingency may not be that palatable, but it's bound to change, and we're bound to see more of this. Third-party funding took a fairly slow start. I think it's fair to say there's been a big uptick in the numbers of funding notifications, third-party funding notifications, and I think there's been an increased renewal in third-party funding since OFSA came into effect at the end of the year, and I think that's likely to happen. It's maybe not like ChatGPT. ChatGPT was November last year, so a month prior to us, is already into its fourth iteration. We're a bit slower than that, but we do see this trend continuing, not least because it's just another pricing toolkit. And people are talking about it and wondering how it fits into their practice, and clients want to know whether they can benefit also. As Sheila said, the final point I make is that we're likely to see an increase in insurance products, because I think it's fair to say that particularly the more complex the arrangements, as Rory said, they can be pretty complex. But commercial arbitrations can get pretty complex too. And it's usual that we at least will have an insurance product alongside anything where we are taking on significant risk and a client is taking on significant risk. And there are insurance products that can be bought where the law firm can insure its WIP to protect it for perhaps the more sort of contingency style arrangements that are being put in place. So I expect to see the insurance market changing quite considerably. We are getting calls from insurers and brokers now, I would say on a weekly basis, saying what can we do and how can we get into the market. Hong Kong is a capitalist society, so I think it will grow, and it's quite an exciting time to be in this part of the world. Thank you.
Thank you very much. Now we actually a bit ahead of time, so we have time to invite our esteemed panel to respond to the questions that you, our audience, have kindly submitted. And if I may, I'll take them from the earliest. So one colleague has asked this. As OFSA is a new concept, can you explain what arbitration cases are suitable for using CFA, DBA, and hybrid DBA respectively? Now, who would like to kick off with that? You want to start, Kath, and then ask colleagues to add? Thank you.
I think sort of the most suitable cases that involve payments of damages often are perhaps the most simplest, where you know there's going to be a specific, if there's going to be a range of outcomes, then that gives you a lot of flexibility. So it's not just a binary outcome whereby, for example, in a private capital dispute, someone's suing for the termination fee and that's one number. So either you win or you lose. Where you've got a range of potential outcomes, then it's actually it's easier to structure that you'll get, you can structure, say, 5, 10, 15, 20% incremental uplift depending on the outcome in the arbitration. And you start with a threshold number, and then you say, so anything, if we have to pay anything less than 30 is a win. If it's 30 to 25, then I'll pay you a bit extra. If you get me down to 20, this is on the respondent side, I'll pay you a bit extra. So that's a really easy way where you have a range of damages and a CFA perspective where you can have a permutations of outcome. And I think for those of you who were there at the Hong Kong ADR conference, it's very rare to have one success, one outcome. There's usually a range and clients get a menu depending on where the ball falls. I think it's a bit more difficult when it's a binary position. I think DBAs suit themselves to very complex, high value, and really then you're looking at DBAs or hybrid DBAs, which are really the same thing, but you're just pricing that risk differently, and you might bring an insurance product in on a pure DBA that you might not use on a hybrid. Long running, very complex, but lots to play for, and that's where clients and lawyers are willing to take on a bit more risk.
Thank you. Would any other panelists like to comment? Cameron?
I'll comment. I think it's worth remembering that this is wonderful flexibility that Kath and you, Kim, have sort of helped to implement into the laws here. I think first and foremost, this is designed for access to justice. So I think that's worth bearing in mind. So, Kath's client has a good claim, but literally cannot afford to bring it against a big corporation that has the ability to pay. I mean, that screams out for this sort of assistance, I think. And then beyond that, for me, it's about, as Kath has said, open conversations with clients about what suits their commercial interests. Some don't want anything to do with this. They want the sort of traditional, if I can call it that, Hong Kong approach of you do the hours, I'll pay you that rate, and I want to get some understanding of where it's likely to end up, but we understand litigation's uncertain, and we're happy with that. We don't want to share uplift. We don't want, and we want, from their perspective, alignment is best achieved in that way. Others take a very different view.
Thank you. Anyone else like to comment? Sheila?
Kim, I think the only thing to say is that, again, the point about access to justice and actually giving clients the optionality whereby I think some years ago, for those of us who did a lot of, have been doing a lot of cross-border cases, you can see further away from Asia, these options were available to our clients right from back then. And actually, sometimes they didn't look at lawyers in this part of the world simply because we weren't able to offer them the same service. So it's access, but it's also options and, being able to allow them to manage their business and risks better and sort of trying to understand it from their perspective. So that's sort of one where I think sometimes, suggesting it to even clients who you may think, why would they need it? Actually, they really quite like the suggestion sometimes and just the idea that we were thinking about it, to a point that Kath made earlier. I think the second point is just be careful about how you define success. I have had a situation where the client asked us to consider it and we said, sure. And then we came up with our own definitions of success, us and them. And then when we matched it, it was quite different. So I think you do want to think about what success actually means. And in situations where sometimes there isn't money involved until quite late in the phases of the arbitration, for instance, so say earlier parts are declaratory relief or quantum is bifurcated, then again, you want to structure it carefully so that you're not agreeing to a fee that you're only paid in, say, 10 years' time, because we also have our own businesses to run.
Thank you. Lee Jun?
Well, I think for all the complex commercial cases, if the charge is on hourly basis, CFA should work. So that's why I think it's also attractive for us mainland Chinese arbitration practitioners. But DBA, that's quite tricky. I mean, for all the Hong Kong lawyers, if you have a PRC clients, probably it's acceptable because that's already in the culture. That's their habit. All the SOEs, they tend to have this some sort of contingency arrangement in order to encourage lawyers to do good work. That's already in their blood. But otherwise, if it's I don't know about too many clients, but if it's clients from overseas, you better be careful. For example, for third-party funding, the founders told me they only finance 5% of cases. If I mean, for the lawyers who are offering DBA, it's in similar situation. Only if you are so confident about the case, you will agree to such arrangement. But in that situation, would the client give you a high percentage? That's doubtful.
Thank you very much. So then, shall we move on to the next question on OFSA? If we have time, we'll go to the one on third-party funding. And this question is, and if I engaged a team of mixed jurisdictional lawyers under OFSA and later realized it's not allowed in their jurisdiction, would that render the OFSA agreement invalid, and how can I seek relief? Who would like to lead off with that one?
Kath will answer that one.
Oh, sure.
My instinct is that it doesn't render the OFSA agreement invalid, but it might put the lawyer in that jurisdiction under potential issue with their regulatory body.
What else like to comment on this?
Suppose we charge over 18%, right? And then the client told us, this is invalid under Chinese law. Would that part of a contract clause be deemed as void, invalid? I think most likely no. I agree with Cass. In China, it's a similar situation because all those provisions that I cited earlier when I speak, they are mandatory provisions, but it does not affect the validity of the contract under our laws. So eventually, it's a compliance issue rather than contract validity issue.
Thank you. Sheila?
Just one comment from me, Kim. I can't help but wear the hat off. I do a lot of work in India, and that is a jurisdiction where propositions get tested much quicker than sometimes in many other parts of the world. And I think that this distinction of the consequence of the arrangement, the impact on the arrangement versus the impact of the lawyer is probably something that we see quite consistently, including in India. So for instance, the Indian Bar Council rules actually don't sit consistently with allowing DBA type arrangements. So it's actually quite expressly prohibited. But there isn't any prohibition on maintenance and champity more generally. So the Indian courts, there are two decisions in particular in different courts in Bombay and Delhi who've seen and endorsed actually OFSA arrangements, provided that they're governed by a foreign law. They don't go anywhere near them, and they say, look, this is a matter for that particular legal system, not for us, because that's where the proceeding was. But if there's a particular lawyer who appeared, then the consequence on them may be different. So I very much agree that that's probably the distinction, and it wouldn't impact the validity of the OFSA as long as you're in the right place so far as that's concerned.
Thank you. Now we have a question about third-party funding, and if I may, maybe I'll have a first shot at this. This question is, why is third-party funding, and I'm assuming this is in Hong Kong, allowed for arbitration but not for court litigation? How can we assure that the OFSA will not be abused, e.g. officious intermeddling of arbitration process? Well, maybe others could answer the second one, but the first one, in terms of the reforms for third-party funding for arbitration, the Law Reform Commission Subcommittee was expressly instructed that we should look at this in the context of arbitration, and that is under the arbitration ordinance. And this was because championing and maintenance and barratry is still torts and crimes in Hong Kong, and it was thought it was too far a way to go to start looking generally at whether or not third-party funding should be allowed for all contentious proceedings. Hence, we started with Hong Kong has started with arbitration, but as I mentioned, the definition of arbitration, if you remember very quickly, in the arbitration ordinance for third-party funding, but also a similar one for OFSA, is arbitration, emergency arbitrator proceedings, mediation under the arbitration ordinance, and litigation under the arbitration ordinance, but not otherwise. Apart from that, as you know, with the doctrines of championing and maintenance, there are exceptions permitted, including access to justice and common interest, and what is a lovely category, miscellany, which includes insolvency proceedings. So there are certain circumstances where litigation can be funded. But I can see Kath has her microphone poised, and there's also that second part of it. Over to you, Kath.
The question was, how do we ensure that officer is not abused? Was that the question?
Pardon me. How can we ensure that the officer will not be abused, e.g. officious intermeddling of arbitration process?
Okay, by?
That's the question, but I guess it gets back to how can we make sure it's properly...
So I guess the first thing I would say is, again, for the similar reasons to third-party funding, it's only available for arbitration and arbitration-related court and mediation proceedings. So it's just, and that's really a commercial arena. There's an, and I didn't say this at the outset, and I should have done, because of the, I won't use the words that Cameron used, but because of the historical associations of these types of structures in a personal injury context, personal injury claims are expressly excluded from the ordinance. Now, I think in a commercial arbitration, I think the risk is low because personal injury claims that are arbitrated tend to be insurance claims. It's not that you fall over and sign an arbitration agreement with a person whose pavement you've tripped over, but we've excluded it expressly to ensure that we are really keeping this to the arena of commercial disputes. What I will say, we brought this into the limelight, and it is a regulated regime. We know that it was that success fee arrangements were happening long before OFSA came into force, and we call the black market of OFSA. And what we've done is we have regulated it. We have deliberately made the rules clear and binding, and there will be if either a lawyer or a third-party funder is meddling needlessly in the arbitration process through OFSA, which it's hard to see how, but then that is regulated both, as Sheila said, by the courts and also by the professional bodies. And I think that we've deliberately made the rules binding, and it's not just a code of conduct for that reason. And parties have to notify these structures when they are put in place to the tribunal and to the other side, and that's another safeguard that we've put in place. So I think, there are risks in everything, but you can't not do it just because people might behave badly. We're lawyers, so we have to be trusted at some level, I think.
Thank you very much. Well, they were the three questions that were asked, so we have about 2 minutes left. And there was one question, which was this very broad question, which our panel briefly discussed, and ask you all to comment briefly. How should lawyers approach risk in this context? Starting with Kath and moving along. Thanks.
Carefully. I think it's a couple of things. One is think carefully about how you price. Think carefully about potentially your portfolio. If you're, don't do every case on a risk basis. Think about, as we saw, products that can help you mitigate that risk. When I talked to a third-party funder about this, he talked about confirmation bias. So just be wary of confirmation bias. I think when depending on what risk you are taking on, then it makes you look at the case more carefully from the outset. And that is a very good thing, I think, for lawyers. And I know that a couple of accountants came up to me at the ADR week and said, there's a real role here for accountants because people don't think about damages until 2 weeks out from the merits hearing, frankly. And actually what this does to the question that we answered earlier about how do you structure these types of cases and what's suitable for a CFA and a DBA, thinking about the likely outcome, whether that's declaratory relief, whether that's damages and what that might look like, is a way of assessing that risk. And I think that's got to be, you know, a positive thing for both how lawyers and clients approach the merits of a particular dispute at the outset.
Thank you. In our 40 seconds left, anyone else like to comment on how to approach risk? Thank you.
I agree with Kath. I think carefully is entirely appropriate. I'd add to that transparency with the client up front, and it's required under the Australian rules, and we've heard others about precisely when success is achieved and what the consequences of that are for both the lawyers and for the client. And in my experience, that transparency needs to continue throughout the mandate, almost reminding the client this is how we've structured it.
Thank you. So we've finished dead on time, and may I ask you to join with me in thanking our panel very much.
Thank you so much. Please come forward to the stage for our group photo. Yes, let's come forward to the stage for our group photo, our panelists and our moderator. Thank you for the precision and the efficiency. Let's come forward. Also give her a thumbs up for the great work. Let's look at our camera to take a few more pictures. Li Jun. All right, thank you very much. Please take a seat. Thank you so much. Please take a seat. And may I now invite Mr. Clifford Tavares, Principal Government Counsel of the Legal Enhancement and Development Office, the Department of Justice of the HKSAR Government, to deliver the closing remarks. Mr. Tavares, please.
Distinguished guests, ladies and gentlemen, it has been a real pleasure being with all of you here today, seeing you all in person and also online. On behalf of the Department of Justice, thank you for joining us on Day 3 of the Hong Kong Legal Week 2023. Our gratitude to all the partners, moderators, and speakers who have helped put together this event and made it a great success. From commercial mediation to arbitration, from regulatory framework to practical experience, and from regional context to the international context. Through the various panels today, we have, from different perspectives, examined many pertinent issues on mediation and arbitration. On mediation, we have talked about cross-border enforcement of mediated settlement agreements, enhancement of mediation, professionalism, strengthening of capacity building. On arbitration, of course, we have discussed some latest developments domestically and internationally. And of course, we have shared the diversified dispute resolution services that Hong Kong can offer to users both far and near, and how Hong Kong is uniquely placed to contribute to the national development with its legal strengths and with the benefit of collaborating with our counterparts and partners in other places in the mainland. Today's morning's session signifies the 6th time that we joined hands with our Shanghai partners in discussing how the development of commercial mediation for effectively resolving cross-border disputes helps contribute to the building of a law-based business environment and the need to address convergent issues between the two jurisdictions and to ensure the high quality of mediators through suitable training mechanism. Later this evening, The 5th Hong Kong Mediation Lecture will continue to explore further opportunities for mediation as an effective and efficient mechanism for resolving international disputes. The afternoon session began with an interesting dialogue addressing the contemporary trends and latest global developments in arbitration, covering novel areas such as the interplay of AI and ESG with arbitration. The last panel discussion of today featured a focused discussion on the new arbitration funding options available in Hong Kong and experience sharing of the practice of arbitration funding in other major arbitral jurisdictions. Seeing many experienced practitioners and such an impressive audience from the region and the local legal sector, and as Catherine has briefly mentioned, I would like to take this opportunity to share one latest news on OFSA. Now, our OFSA regime, comprising the amended arbitration legislation and the supporting rules, became fully implemented in Hong Kong in December last year. Being the latest addition in the arbitration funding spectrum, both locally and internationally, with the benefit of valuable references from overseas practice, Hong Kong's OFSA regime, with its variety of OFSA agreements, we believe offers diverse and flexible funding options to arbitration users that can suit the needs depending on the circumstances. Coupled with the third-party funding of arbitration regime, which came into effect in February 2019, we are proud to say that Hong Kong provides comprehensive arbitration funding options in addition to traditional fee arrangements, not only to keep up with international practice, but also to cater for the evolving needs of arbitration users and to enhance access to justice for those in need. Indeed, statistics shows that as of September 2023, it was disclosed that 87 arbitration cases were conducted with third-party funding and 4 arbitration cases were conducted with OFSA. As the first anniversary of the OFSA regime approaches, it is encouraging to see that the OFSA is gaining momentum by being put into real practice and good use in the arbitration community, among other funding options. As part of our ongoing efforts in providing legal guides and tools to facilitate the use of arbitration funding options, in February and August this year, we have published a leaflet on funding options for arbitration in Hong Kong and a set of top 20 frequently asked questions, FAQ, on OFSA, respectively, to introduce the key features of arbitration funding options in Hong Kong. Both items are available on the DOJ's website. Now, to further assist users of OFSA, I'm delighted to announce that a guidance note and checklist for OFSA is published today. The guidance note and checklist provides practical information to assist arbitration users who wish to enter into OFSA agreements and serves as a handy tool for arbitration users to ensure that their OFSA agreements to be entered into are valid and enforceable. Hard copies of the guidance notes and checklists are available on site. You may, of course, also download it by scanning the QR code displayed here. Thanks must go to the members of the working group on OFSA checklist for the dedicated support and insights contributed in preparing this piece of user-friendly tool, which I'm sure will benefit the actual potential users of the OFSA regime. Ladies and gentlemen, echoing the theme of today's event, we are entering into new domains in mediation in terms of taking measures to further enhance mediation professionalism domestically, enhancing our contribution to the GBA development and the Belt and Road Initiative regionally, and contributing to resolution of disputes and related capacity building internationally, particularly through the work of the International Organization for Mediation Preparatory Office and the ongoing investment law and investor-state mediation training that we have been arranging. We are also entering into new domains in arbitration with the multiple funding options offered by the new OFSA regime. And we of course, welcome you all to come to Hong Kong to join us at the ICCA Hong Kong Congress in May 2024. Going forward, embracing all these new opportunities, Hong Kong as the Center for International Legal and Dispute Resolution Services in the Asia-Pacific region under the National 14th Five-Year Plan will continue to make good use of its unique edges in providing advanced dispute resolution services for all. On this note, may I once again thank our co-organizers and all the distinguished panelists for the insightful sharing and all of you for joining today's event. Wish you all a pleasant evening. Thank you very much.
Thank you, Mr. Tavares, for the details and very encouraging remark. Please take a seat. Ladies and gentlemen, we have come to the end of today's new domains in mediation and arbitrations. On behalf of the Department of Justice of the Hong Kong SAR of the People's Republic of China, a big thank you to all our excellent speakers and moderators and our participants here and those watching the live broadcast. Thank you for attending today's event. Please take a moment to complete the evaluation form by scanning the QR code as you can see on the screen. Before you leave the hall, please remember to return your headset. For CPD points of the Law Society of Hong Kong, in-person participants, please be reminded to check out at the registration desk for record purpose. The 5th Hong Kong Mediation Lecture will be held at the office of Herbert Smith Freehills on 23rd floor, Gloucester Tower, on 15 Queen's Road Central at 6 to 8 p.m. Participants who have registered for the lecture, please kindly join us at the office of Herbert Smith Freehills by 6 p.m. or log in with the online link provided. See you tomorrow for Day 4 of Hong Kong Legal Week event. Thank you and see you tomorrow. Have a great day. Thank you so much.